All right, we're sort of sliding into our last 15 minutes. What I'd like to spend time now on are future agenda items and be as specific as possible. One that I would have is the one I mentioned earlier, where we would look at specifically access to justice, race equity and inclusion, client protection fund, the Keller deduction, and sort of an understanding of where that is money-wise and whether we think it fits within what we would call the regulatory side of the house. So my dividing between regulatory and voluntary, I'm not advocating having two separate ones. I'm just advocating identifying stuff. If we think it's clearly in regulatory, and I think we could maybe come back with a list and go like click, 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 licensing, discipline, the bar exam, MCLE regulation, not necessarily MCLE service. Then those just get set aside because those anything we have, they're there still. Okay, then the rest, then you start saying we take sort of the hard ones that we think are on the would be on the cusp kind of or on the fault line, and then ones that if you were going to say unless something changed, we would think most people would identify them as voluntary, and how that would work, and then which ones we would pull over, which ones we'd say, well, no, we think they really are over here, but we think we can perhaps establish a way to keep them under a umbrella organization. The other thing that would be interesting, I think, to find out from the bar is sort of the whole association side, just sort of as a lump. I know you presented it generally, but and I'll go back and review the notes, but sort of the overhead and how much it actually, are they, how self-sufficient are they? Is everybody okay? Which ones are the ones that are kind of teetering or that you would feel might not survive if they had to really just be paying their weight and being just administered through the bar? So those are ones that immediately come to my mind that I think we could, a lot of that we could chunk off pretty quickly in a meeting. Others, why don't we just go around, and I'm just going to go around so everyone has an opportunity to speak. Esperanza?
Thank you. I think I made a lot of notes about what I think, and it would take me longer to say it. So I had mentioned earlier last week that I would submit something to you in writing.
Wonderful.
And that's what I'll do because my thoughts are coming together on these issues.
Wonderful. Thank you. We'll look forward to that. Jane?
I really don't have anything to add. I think you've pretty well summed everything up that I would have liked to see on next agenda.
Hunter?
The only potential addition I might throw out there is something we had talked about previously, maybe hearing from some of our lawyer legislators who have worked on this issue for some time, Senator Padden, Senator Peterson. I pointed out Representative Stokesbury felt sufficiently strongly on the issue to drop the bill originally, even though it was significantly changed. So that would be my only additional
and Representative
suggestion.
Jenkins, because she's
Yes, of course, Representative Jenkins. Thank you.
Okay, thank you. We'll see if they're available, and at the end, I'll take a little poll as to what others think. Eileen?
Well, although we've used the term regulatory side, I think that the case law is a little broader. There is protection of the public and improvement of the legal profession. So I would not want to lose sight of those components as part of our consideration. As for the next meeting, just 3 quick points. So Dory and I had talked, and the ACLU has said they would be prepared to present. I told them like 20 to 30 minutes, not a whole hour. If you don't want them to come, let me know, and I'll call them off. I think they will still put in written comments, but that is something that was going to be available. We, the section representatives, met with, I think, Paris is her name?
Yes.
And there's an invitation to do a meeting on the 18th with just the leadership, to the three of us, to try and see what they want to say, just another effort to capture comments. Maybe no one will come, but it's an effort on our half to do it. And the one other sort of in the mandatory side, I don't know what you would call it, is I think the Court Rules Committee, which does deal with the operations of the court and is pretty central, obviously, to how the courts are run, is something that should be seriously considered as under the both protection of the public and the needs of the legal profession to operate efficiently.
Thank you. Mark?
I think you encapsulated what we should do and what we should consider perfectly, Madam Chief Justice, so thank you.
Thank you, Mr. Johnson. Dory?
So I've made a list based on what I've heard discussed, the character fitness test, both of those being part of admissions, annual licensure, discipline, CLE regulation, ethics regulation, access to justice, diversity, equity, inclusion, lawyer assistance program, and the court rules program now as the functions that we would want to most closely scrutinize to see what that looks like on the regulatory or mandatory side, whatever we call that. So if anyone has any additions to that list so that I can engage with bar staff and make sure that they are, maximizing the time they have available because it's a short turnaround time, then I'd want to know.
All right. Andrea?
I don't have much to independently add. I just want to share these few quick comments that I got back from feedback at the WSB listening tour, because I said that I would be a conduit of information. Where we place this at, or just in terms of how this goes on a future agenda, I'll defer. Some have expressed a sentiment that they would like for things to slow down a little bit. They that the work group is still new to them in terms of what's going on with the work group and where we are in our process, and they're just now catching up. Again, just sharing the information. Some have expressed that there should be an analysis of the separation of powers issue that might arise in the context of the Supreme Court being the body that regulates in addition to creating the rules around enforcement of practice. And some have suggested that the moment be seized to address the nuances around Keller, that looking at a modification of Keller, they don't believe to be independently sufficient to address the issues. So those are just some.
Can you say the very last thing after nuances around Keller?
Right.
I didn't understand it.
The thought was that just looking at the Keller deduction and modifying that was not independently going to address the other issues. So
not enough.
Yes. Okay. Thank you.
Thank you very much. Kyle?
Andrea, thank you for that. That differs a little bit from when I was on the listening tour for the Southwest Washington 3 or 4 that we did. And just to piggyback on what you said is that listening tour, that has been very helpful to figuring out what is in the minds of the membership, at least those people who have turned out. And without exception, for the ones that I've been on, we've talked about the structures work group. They seem to know what it's about. They have questions about it, but not concerns necessarily. And we even got into the weeds of Keller and opt-in and opt-out, which sometimes loses folks and people's eyes glaze over. But they're interested and they're interactive, and that was encouraging for me. So. It's been a good learning experience. I think we continue these in the future, and it's an excellent way of reaching out to the membership and finding out what they are thinking and believing and want to see in the future. So I'll add that.
Agenda for next items?
When
Other
I
than
started,
what you've heard?
the only other thing, and maybe this is too much into process and not the 30,000 foot level that we're thinking about, but one of my considerations for opting in was, why would people opt in? And we need to have some kind of incentives and some kind of benefits for people doing that. And we haven't talked much about that. And maybe that's more of the how-to than should we. But it's something that we should think about long term, because there's a lot of benefits that the Bar Association offers to its membership, and a lot of those could be encouraging for folks to say, yeah, I don't like that part of it, but I do like this part of it, and so therefore I'll opt in.
Thank you. Paul?
Well, I don't really have anything to add. I think it's been a very good discussion, and really appreciate all the different perspectives that folks have brought to the table. I share the concern that access to justice, equity, and inclusion needs to be a priority as we move forward. And I think under some of the issues we've discussed, that might be one of the more challenging, one of the things that we need to focus on in light of the pending cases. I also look forward to seeing the information that the staff is going to be bringing to the table, maybe around how we would allocate costs, or what would look like to opt in to essentially have some voluntary aspect to an integrated bar association that addresses and contemplates any potential litigation, and puts us in the best position to deal with those issues.
Thank you, Paul. Fred?
The first point, I hope there's something that we can take off of our discussion agendas, in that we either reach an agreement that there is a majority position or there's a unanimous position, and that's with respect to the access to justice and race equity and inclusion issues. I've heard most everybody talk about this, and Hunter was articulate in saying there may be some risk in doing it. We recognize the risk, but I haven't heard anybody say we should take that out of our mandatory functions. And so, maybe we can call that question, are they in, and do we need to keep saying that they should be? The second point is maybe one that I'm still a little confused on, is I'm a real proponent of the sections. I'm not a member of the sections that have spoke here, but I've been a chair of a section, and are they self-funding? I mean, I've heard that they are and they aren't. If they're self-funding, that's voluntary, and we don't have a problem, and can we deal with that? So I'm confused on that, so I'd hope that one is still on the agenda. A third point that may need some discussion again is Mark has talked about, is the role of the Supreme Court in its relationship with the BOG. I think we need to make some sort of recommendations on that. And the final piece is, we might get some legislation if we do nothing. We should have on our agenda what we're going to tell the legislature, or the Supreme Court, or both, should be done on the legislation. Yes, pass it. No, don't pass it. Or pass something different. Those are my 4 points. Thank you.
Thank you. Andre?
Nothing further at this time, Your Honor. Thank you.
All right. We're checking to see if Dan Clark has anything. Margaret, can you see if Dan Clark has anything for us?
I'm fine right now. Thank you.
Thank you, Dan. Nice to hear your voice. All right. Well, I think we have good suggestions. We'll look forward to Esperanza's in writing. I've taken good notes. I think we'll fill up a lot of the next meeting with this continuing discussion, try to hone in. I want you to keep the 2 optional meetings on your line. I'd like to, if possible, give about a half hour set aside for public comments, because people are interested. To the best you can, keep up with the reading. Yes, Esperanza, please.
Sorry, I want to catch right before we're done. I want to take you up on that, about are we in with access to justice and race equity and inclusion, and whether we leave this on here or not. And not leaving it on here is because we all agree that it is part of who we are and what we do. And why can't we call the question on that right now?
Well, we could, but I have 3 minutes, and I'd like to call it at the beginning of the next meeting if we could, if that'd be all right.
Yeah,
because
I agree.
I think, well, I completely agree too. I think that talking about whether it's in or out, we should just make that decision, and then with that decision, see how you bolster it or set it aside. But I really like to be timely because it gets people here on time and they are confident they can leave on time. Our next meeting is at the bottom of your agenda now, so I can find it easily, and it's June 26th. So it's 16 days away, so we actually have a little chunk of time, and we're going to the afternoon again. We're sort of switching between morning and afternoon to help with people's conflict. So it'll be 1 to 4 p.m. here at the bar offices. Is there anything else for the good of the order? Any other thoughts, comments? I can take your yellow expense sheets back if you're turning them in, or if you're not turning them in, and I brought you one at your request. All right, hearing nothing at 11:58, I'm going to adjourn the meeting and look forward to seeing you all in a couple weeks.